One of my very first clients in probate actually was a 90-year-old woman who was very upset when she met me. She was not upset at me, but she was mad at the banks and at the judges because when she went to them and said, hey, I've been married for a really long, 40 plus years to my husband. We did everything together. We had a really strong relationship. We had the best relationship on this side of the Mississippi. And every single time she said that to them, they said, great. What does his estate plan say? And what are his assets titled as? We don't care about the relationship. And that was very frustrating to her, which is totally understandable. But that's the misconception I wanted to talk to you today about. Before I dive into that, let me tell you how to reach out to me. You can go to my website, www.legionlawpllc.com. You can schedule a free consultation on the phone. So that is a major misconception that I'm working with pretty much most of my probate clients. They say, I've been married for so long, there's absolutely no way that I wouldn't be able to look at a bank account in my spouse's name. I wouldn't be able to transfer their half of the house to me so I can downsize the house. There's no way because we've done everything together. And honest to goodness, that's just not true. It's one of the biggest misconceptions, and it's a really tough misconception to explain to people because that's tough to explain. You've done so much together, and that doesn't matter. That doesn't amount to anything. What matters is what the estate plan of the deceased person was at the time of their decease or passing away. So if they had a will in place, great. If they did not have a will, did they have a trust? What was the title? So did the account have both of your names on it or just one name? There are a lot of different questions we need to figure out per asset, but none of those questions ever involve how long were you married and did you guys love each other a lot, And so that emotional part is really such a tough part to overcome whenever you look at the technical paperwork legal side. It can come off very cold and heartless on the legal side, but in reality, judges hear sob stories all the time. Judges don't know your relationship. Banks don't understand your dynamics. They just want to see the paperwork. They just want to make sure the laws are followed and that their procedures are followed to the T. So please don't have the misconception in your mind that, well, we don't need an estate plan. We've done everything together and there's no way we wouldn't be able to access everything after somebody passes away. It's just not true. You're definitely subjecting yourself to a very, very dangerous thought process that's going to lead you probably to probate. And I don't want you to be like that 90-year-old woman coming into my office and being very upset and kind of getting a little feisty with me as I try to say, hey, hold up. Here's why that's the case. I don't like it just as much as you, but here's why. So that's the biggest misconception. It's a big one, and please don't subject yourself to it. If you have any other questions on this or anything else, you can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, www.legionlawpllc.com. You can go to my website's Contact Us page and schedule a free consultation over the phone with me directly. So thank you so much for watching, and have a great day.